Hello, everybody. It is Dennis Block with our special New Year's Zoom Landlord-Tenant Talk Radio coming at you this December 3rd. And I wish everybody a very happy New Year. And I'm glad you guys could all come out for our weekly session of our Zoom Landlord-Tenant Talk Radio. Always appreciate your participation in this. We have a interesting situation now with the city of Los Angeles, which will be my opening topic. And it also affects unincorporated areas of LA County. And that deals with something called the fair market value. Recently, based on the housing and urban development statistics, those figures have raised. The concept with the fair market value deals with that they have set certain amounts for depending on the amount of bedrooms that you have. And you cannot serve a 3-day notice unless it exceeds that value. So I want to show you this. I'm going to share my screen here. Let's get rid of that. Okay, so what you should be seeing now is the new fair market value, which only affects, again, every residential property in the city of Los Angeles and every residential property for unincorporated areas of LA County. If you are attempting to go forward with an eviction, you can, for non-payment of rent, of course, then if your rental amount does not exceed that fair market value, so let's take a 1-bedroom, it has now been raised to $2,006. So if you have a 1-bedroom apartment that goes for $2,000, and I think most of us do, I certainly do in some of my buildings, that would mean that I could not serve a 3-day notice if the rent for December is unpaid. I would have to wait until January, which would be a total of 2 months' rent, which would be $4,000. So recently I had a client call me who had a single unit, an efficiency or a bachelor's unit, which does not have any bedrooms. And if we look at this chart here, it's $1,777. Now, the rent that he was charging, and this has been a long-term tenant under rent control, was $850. So certainly, if the tenant didn't pay for December's rent, we'd be below the threshold. But if, in fact, we get into January, it's only going to be $1,700, which means, as I tweeted out, and I had about 6,200 people saw this tweet, that this poor gentleman is going to have to wait 3 months, 90 days before he can serve a 3-day notice. This is insanity, ladies and gentlemen. This is the state of law that our politicians have put us into, but yet we're sitting there without revenue for 90 days before we can first start an eviction. And we all know an eviction is not going to take 1 day. It's going to take 2 to 3 months. So literally, they've allowed these tenants to sit there basically 6 months without receiving any rent. Ladies and gentlemen, this is insanity. And this is what we have to deal with regard to our politicians. So it is a very sad state of affairs. And that is the topic of the day. Make sure that you are above the threshold. And of course, what is that really telling all landlords to do? It's telling landlords that, and here you would think the city council of Los Angeles, they're trying to make more affordable rents, right? I mean, right? That's what at least they think that they're doing, as opposed to just putting a bunch of hurt on landlords. But which landlord would ever rent a 1-bedroom unit at this time for $2,000? You'd have to be crazy. And since the fair market value keeps going up every single year, the least you could ever charge for a one-bedroom apartment right now, it's got to be about $2,400. It used to be that it was $1,776 last year for a one-bedroom apartment. Now it's 2006. So on that basis, ladies and gentlemen, you have to reevaluate your rents, because if you can't serve a 3-day notice when rent is due because of this craziness with fair market value, you're really going to take a financial loss. So again, learn that chart. And this telecast, this Zoom meeting will be broadcast again. You can get this online, or you can just review the video online that I'll be posting very quickly after this meeting is over. But make sure, if you're ever renting out units at this point in time, unlike what the city council is requesting, basically affordable rents, no, they can't be affordable. They have to be above the fair market value. Anyway, that's concludes my little speech for this Saturday in our special New Year's edition. We're going to move along right now to some of our callers. The rules, of course, are please do not talk about an existing case. Please do not talk unless you're called upon, and please electronically raise your hand so that I know that you want to speak. And please, as many people as you can, because we have an hour to go here and I want to get through everybody. So please do that. And also understand that everything I say today, even though I do have 47 years of experience in dealing with landlords and tenants, I can't believe that figure, but it's true. Everything I'm saying today is for informational purposes only. It's not a substitute for getting legal advice. I do have to state that, but, and of course, we're always happy to have you call the office directly where we can truly key on your problem. And today we're going to go a little bit out of order for once, and I'm going to pick on Laura Corral. I'm going to ask you, Laura, to unmute yourself if you'd be so kind.
Hi, good afternoon, Dennis. Thank you for all you do, for sharing your wisdom with us. My question is today about surveillance. So we have the Ring camera, and as we know, the Ring camera doesn't capture anything unless there's motion. So it's not really recording 24 hours. Do we have to put a sign on our building saying like, oh, there's 24-hour surveillance, or any kind of camera if it's an outdoor camera?
Well, that is not required. Video is, you can do surreptitious video, surveillance video. There's not a problem with that. You can't secretively record their voice, though. That's against a California law. It's considered a felony. So if you're going to do that, you have to have a sign posted that you're recording their video. But if it's just a Ring camera and you're not recording the audio of it, then you're fine.
So if it does have audio, I have to put a sign.
You have to put a sign, or what you can do, because really you just want to see the guy stealing the packages or breaking down the door, you just turn the audio off. That's all. And you can do that on a Ring camera.
Okay, quick second question. When it comes, so our properties within RSO, rank increase is 4%. We could also go ahead and increase the security deposit.
Yes, under the RSO rules, at the same time, you can increase the security deposit the same amount that you're increasing the rent. So it'd be a 4% rent increase on the security deposit.
So if we've never done that before, can we start with that this year or
It
no?
would be a total of 4% this year. That is permissible.
Okay,
All
got it.
right. Anyway, thank you very much. I am going to mute you, young lady, and I'm also going to lower your hand. We're going to move now on to, let's move on to Dina. I had to take you out of order, but I'm going to ask you to unmute yourself, young lady.
Hi, Dennis. Thank you so much for your support and time and everything. Before I'm going to ask you my two questions, I watched your very, very good video, not with the Zoom. It was with the Orange County, I think, Association about security deposit. And I did my homework, but I had two things I'm not sure of. I want to ask you about, because you said that we can do estimates when we don't have time to get the job done before the 21. So I have some jobs done for repair, and I have estimates for the cleaning, which is going to come after the 21. So with the first time, I'm going to do the itemization, not the final, and send whatever I have receipts and send also the estimates, let's say, for the cleaning. However, how much time I had, and the first question, sorry, do I still have to send the later on the receipts for the cleaning, or just the estimate is okay? And how much time I have after the 21 to send everything and to do it? And it's
Okay,
okay to do it
so
after
you,
the 21.
okay, so it's okay just to send estimates as to the work that's going to be done. That all, of course, has to be done in 21 days. If you can't get estimates or your actual receipts, then you have to tell them that I didn't have enough time and I will mail them to you. I would do it certainly within 30 days after that 21 days expires.
Oh, 30 days from the 21?
Yeah, I mean, you don't want someone to come back and sue you, so I would definitely try to get to the estimates in the shortest possible time. I certainly would not exceed 30 days.
Yeah, no, and I'm gonna even send the estimate, then it's before the 21. But my question here, is it okay if I send the estimate and do the work after the 21? Because I didn't get time to do everything. So the cleaning has to be postponed after the 21.
Oh, that's fine, but you have to
Oh,
just say that I haven't been able to complete all the estimates or have all the receipts. I will give them to you as soon as they're available. I would try to do it certainly less than 30 days, probably more preferably in 2 weeks after that 21-day period.
should I tell them that?
Yes, of course, that you're supposed to still do your security deposit itemization. You
Right.
have to send that to them, but just include, this is what I think it will be. And I will send you the receipts within 2 weeks or 3 weeks, and then I'll make a final adjustment. But you must send a security deposit itemization within the
Yes.
21 days.
And if it's a little bit different, or I add another job that I am waiting for the HOA to see if they're gonna do it. If not, I have to do it. Is that okay after the 21 days to send another
Again,
estimate?
you have to make mention of that particular work that needs to be
Ah,
done and
I
tell
see.
them that you're going to supply them an estimate once it's received, but it must be contained in your security deposit.
I'll
I'm gonna
do that.
say
Thank you so much.
goodbye, Dina, and we're gonna move on. I'm gonna try and take Jeff Tako. I'm gonna ask you to unmute yourself. Are you there, young sir?
Yes, thank you for taking us. So, I had a question about just cause. We have a tenant so there's somebody who's been less than a year, but we wanted to sell the house, and then there's somebody in the back unit who's on a month-to-month who's been there for 6 years. And so what's just cause to let us be able to end the agreement at the end of the natural contract?
What
What are
city
examples of
are we talking about?
then Hawthorne? We're talking about Hawthorne.
Hawthorne. Okay,
Yeah.
so you have 2 units on one lot
Yes, it's a single family resident with a
with a
in-law.
separate guest house in back.
Yep.
And you got them both rented to 2 different tenants.
Yes.
Okay, so that means you're under statewide rent control. And if you're under statewide rent control, you cannot ask a tenant to move because you want to sell the property. That's not a permissible reason. So
What
What
are
would be?
yeah.
well, number one, what you could do is you could tell them that you're going to renovate the unit. If you are going to do renovation, that would be a way to evict both tenants. Renovation is defined as work that takes longer than 30 days to complete and requires a building permit. So if you're going to like redo the kitchen or the bathroom, get a building permit, like an electrical or plumbing permit, you don't have to do the work to begin with, but it's going to have to be done after they vacate. And you got 2 presumably legal units on the property. And that's an easy way, because first of all, if you're selling the property, wouldn't it be nice that if you did that renovation, you probably get more money for it? If you're also selling the property, trying to sell the property with tenants in possession is a monumental task, because they want to move in. And while, by the way, they can move in, they could ask the tenant to move on the basis that they want to occupy the unit. That's a perfectly permissible reason, but you're going to sit there and tell the potential buyer, look, by the way, as soon as you buy the place, then you can start with the headache of trying to evict these people. So I think the renovation is probably the best way to go. Again, you don't have to do the work, you don't have to get the permits prior, but what you do have to do is you have to make sure that once they're out, that this work on each unit independently will take at least 30 days to complete, that it's uninhabitable for that, because you're going to rip out the kitchen and the bathroom. And then you're going to get your permits. It's going to take longer than 30 days. Both tenants have to go. By the way, we do have to pay relocation to each tenant, but relocation is only 1 month's rent. So that would be the way I would get them off the property at that point. Now, you might also try what we call a voluntary vacate agreement. Some people call it cash for keys. Say, hey, I'm selling the place and I'm intending to do renovation. But I'll tell you what, I'll give you $3,000, $5,000 if you move. And then they move out, then you don't have to do the renovation because we can assist you with a voluntary vacate agreement, which if they sign it, then you don't have to do anything, just sell your property. That might be a better way to go, depending. However, if you do the work and fix it up, you're going to get a lot more money for the place, would be my guess, assuming the place really needs to have a renovation.
Right. And so a follow-up is if we decide that this is too much of a headache and we need to raise the rent in Hawthorne, what is legal and reasonable percentage per year?
Well,
Because right now it's underneath
yeah,
the
you're under
amount that you
statewide rent
stated.
control, so it's 8.8%.
8.8. Okay.
Yeah, I
So,
have to ask, is the rear house legal?
it's not.
Okay, so what you could do, another thing to do, is to call up the Hawthorne Building and Safety and turn yourself in for the criminal that you are. They'll come out there and they'll cite you. You guys do look like criminals, by the way. No, I'm just
Thank you very much. Yeah, I've been working on that.
well, you look like a real criminal. You know, the attorneys, they're all criminals. But in any event, turn yourself in. They're going to give you an order to comply, saying that you can't rent this out. It's not a legal residence. When you do that, great things are going to happen. We're going to need to serve on that person, assuming he's been there longer than 1 year, a 60-day notice to get out. We got to pay him relocation. Relocation is 1 month's rent. As soon as he's out, what you're going to do is you're going to take out that illegal kitchen you put in. And I don't mean you got to break the cabinet, just unplug the sink, take out the toilet, take out the plumbing fixtures in the shower that you created without permit. Just remove them. You can always put them back. I didn't tell you that. You can always put them back. And you can actually make the place legal, by the way. Once that's out, then you've got a single family residence. Well, if I got a single family residence, I still can't ask them to move because they're because you're selling the property. Actually, no, I take that back. If it's a single family residence, when did they move in?
They moved in last March. So it's been less than a year.
Okay, so less than a year? Okay, so once they're out, then we could just serve them a 30-day notice to vacate. No relocation. I don't need anything because they've been there less than 1 year. It's only one house on the lot. You're golden. So I think
what if it's 2 years because we still have to get the guy in the back out? And
yeah,
we're
but
too
once
close
we get the
to
guy
getting
in the
60
back
days.
out, right? Then
Yeah.
it's only a single family residence. And if it's only a single family, actually, no, as I take it back, if that person has only been there less than 1 year, the front house, and he's on a month to month.
Yeah.
Oh,
No, they're on a yearly. They're on a yearly.
Okay. So
We could change it to a month to month. It doesn't automatically renew. We could change it.
Right, but he's been
Or
there
maybe-
longer than 1 year. So under statewide rent control, if there's 2 units on the lot, whether they're
Yeah.
legal or not, and they've been there a year, then you're stuck with trying to figure out a way to get rid of them. So I would think that either do the renovation, the voluntary vacate agreement, or do the or do the turn yourself into building and safety for the illegal unit. Anyway, I'm going to move on. Thank you so much.
Thank you very much.
All right, you
Appreciate
take
it.
care. Let's lower your hand. Let's move on to Sonia. Hello, Sonia. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hi.
Hi, thank you. So my question has to do with a townhouse. There's a tenant there, city of Pasadena. Now, I have a client, so the landlord takes care of receiving the money. The client pays by wiring the funds to their account directly. It's been working well. 1 month there was an issue. The bank changed something where they had to have to speak to someone directly, and considering the person's action, they got some information wrong. So long story short, the funds went to a different account. Other than
Okay,
that
let me
time,
slow you slow you down here. What does that mean? The funds went to a different account. If you're wiring it with a specific wire number, the account number for wires. You're giving them
right.
the routing. How did it go to a different account?
Well, because his bank changed the policy where now they have to speak to representative of the bank. So that first month that happened, when he spoke with the representative, he said there was like a language communication. So they feel that the person probably entered one of the numbers incorrectly. Therefore,
Well,
it didn't get to the
yeah,
owner.
this is not a legal problem. This is get the banks on the phone and figure out where the money went to, right?
Correct. And that's what had happened. So they figured out it went to another account. So long story short, the because the owners didn't find out until a few months later, the bank is saying they can't do anything to help them. So the owners say this is not their problem. They want the rent. The tenant is saying, well, it took a couple months for you to figure out. I think it's a shared
Well,
responsibility.
okay, the tenant is the one who's responsible. His bank sent it to the wrong account.
Correct. Yeah. And so
Okay,
since
so let
then,
me, Sonia, slow down. So his bank sent it to the wrong account. His bank
correct.
is his agent. And if his agent makes a mistake, then it's the tenant's fault. For example, I have a secretary in my office. If she fills out the paper wrong and files them with the court, are you going to look at me and say, oh my God, it's not you, Dennis, it's only your secretary? You're going to say, no, Dennis, you control this process. You hired this secretary. It's your damn fault, which is true. It's my fault if somebody files something wrong, even though I didn't even look at the damn thing. It's my responsibility. I'm the one who has to take care of that situation. The tenant never put the money in your client's bank account. The tenant is responsible. You could serve, I would give the tenant a warning. I would tell the tenant exactly what you're going to do, that your agent, your bank made the mistake. On that basis, and for the other bank to say it's been too long, so I'm going to allow the money to rest in another account, that's beyond stupid. And something's wrong with that part of the story. I don't believe that part of the story, quite frankly, because no bank is not going to rectify it because it's 4 months later or 5 months later. Money doesn't just go into an account, especially on a wire. But in any event, I would tell the tenant that it's your responsibility, pay me or I'm going to figure it out, or pay me. Otherwise, I'm going to issue you with a 3-day notice.
Okay. So thank you for that. No, would there be any problem? Because since then, the tenant's been paying and they are receiving the rent.
We
So,
understand, but right now, like it or not, they're 1 month late.
okay,
So that's it. They're 1 month late.
great. Okay. So do
All
they have
right.
to stop receiving money from the tenant then? Or can they could
Well, we're
still
going to
continue?
serve a 3-day notice. Okay. And if you want, what you could do is serve a 3-day notice on January 3rd, which will include that back rent and also the January's rent. The tenant will try to pay 1 month's rent. You won't accept it. By the way, I don't know any tenant who pays rent by a wire. This is another part of the story that's beyond insane. The wires now are, because I just recently had to send a bunch of money to somebody on an investment deal. Wires are so meticulous because there's so much fraud with wires that, they go up and down and left and right to make sure that the wires are going okay. Even when I sent the wire and they say it's going to get there by 10 o'clock the next day, this is my wonderful, which was this? This was Chase Bank. The next day it didn't show up and they said, well, you have to contact the fraud department. I go, well, if you're not going to send it, why doesn't the fraud department contact me? But of course they didn't. And then I had to get on this phone, get very upset, and finally the money got sent the following day, to my chagrin. But I've got one word for your client, okay? It's gonna be a very strange word, but it'll
Okay.
solve the whole damn problem with one word. And here we go. The one word is Zelle. Zelle it to him. What's the problem? You put in the guy's either email address or his phone number and it gets to him. You don't need to go through a wire, which is going to cost somebody $30 for that money to come in. You Zelle it to him. Every bank does Zelle. Your client sets it up on his where he's going to receive money either on his email address for that account or his cell phone number, and they Zelle it to him. His bank, it takes 1 second. It doesn't cost any money. So not only do you get legal advice here, but we also give a little bit of practical advice as well.
Thank you.
So, all right, Sonia, thank you so much for your participation. And we are now going to move to a cell phone. Cell phones. When I do pick on you, and I'm going to just tell you the last 4 digits of your number, so you'll know I'm picking on you. To unmute yourself, what you need to do is you need to hit *6 for anybody with a cell phone. I'm going to pick the first one is 3726. I'm going to ask you to unmute yourself by hitting *6 and say hello.
Hello, it's Suzette. How are you, Dennis?
Is this Suzette?
This is Suzette. Go Lakers.
Well, we didn't win Christmas Day. That was tough.
I know.
I was very upset. I think we're playing tonight, but
Yeah, we are.
We did win the last game. I think it was Thursday. I was so
Yeah.
tired because I had an office Christmas party that I'm embarrassed to tell you I left at halftime for the Laker game on Thursday. But in any event, I think I got a new game coming up on January 3rd, and I will certainly be there. But Suzette, what's your question today, young lady?
Okay, so my question is, if the tenant overpays by accident but owes a late fee, can I deduct the late fee and then just send back the rest of the money because they pay on Zelle?
Well, the issue is, number one, in order to have a proper late fee, you have to have the proper language in your contract. So if you're using a relatively current rental agreement from the Apartment Owners Association or mine, then that would be then you're entitled to a late fee. If you have a late fee that just says, if you don't pay your rent within 5 days of the due date, you have to pay me $35 or 6%. Those are all illegal. You have to have special language to make it legal. So assuming you have a proper late fee provision and they paid it, I'm not sure why the tenant would have overpaid the rent, but I think it's reasonable for you to apply it towards the late fee. I would certainly inform the tenant that you are applying it to the late fees. Give it to him in writing. Say the rent's $1,000, you paid $1,050. I'm going to be applying that $50 to the late fee, which presumably is why he did that.
Well, no, they paid too early. You know how we get the 4%? And they paid that, and they shouldn't have paid that yet.
Well, right. Okay, so they paid the 4% early. We'll tell them that the 4% doesn't become due until February, but you will apply that towards a late fee. If they object, I'd give them the money back.
Okay, because they paid the late fee before. My late fee is in my lease.
Right,
They
but it has
paid
to
it
have that
before they-
special language, darling. Okay, if you're
Okay.
curious what the special language looks like, take a look at my lease, which is on my website at evict123.com. Go into the free form section and meander down to the left column where it says residential lease, and you'll see and look at the late charge provision. It's got to have something similar to that, not just if you don't pay within 5 days, then $50 is owed. Those are illegal under California law.
Okay, thank you.
All right, darling. Okay, let's move on to another cell phone. This one, again, it's *6 to unmute. And this one ends in 2576. I'm going to ask you to unmute yourself. Say hello.
Hi, Dennis. Hi, this is Cara. I was calling because we have we have gone through an eviction process with our tenant. We have a settlement agreement, and he's supposed to move out tomorrow, and he says he's going to move out tomorrow. which is the date that he's supposed to move out by on the settlement. And so I wanted to arrange for a locksmith to come tomorrow, but technically because he has to move out by the 31st, it says a lockout cannot happen until January 1st. And so I want to see if he does surrender
If the
keys to the
tenant gives up,
property.
let me interrupt you. If the tenant gives up possession
Yeah.
of the premises, you can change the locks immediately. If he says, here's the
Okay.
keys, I'm gone, bye-bye. You don't have to wait to what it says in any kind of a stipulated judgment or an order by the court. You can take possession immediately. He's giving it up. You
Okay.
know, I can give you my
Even
car
if his
earlier if
property
I
is
want to.
And if he still has property, if he still has his property
Well,
on the property, but he gives me the key, I can change
Well,
the locks.
yeah, I would still change the locks on that. You might want to take a look at the stipulated judgment. And a lot of the ones that we prepare state specifically any property left in possession after the tenant vacates can be immediately disposed and is considered abandoned.
Okay. Yeah, that's what it says. Okay.
Perfect.
All right. So as long as he voluntarily leaves, I can change the locks.
Absolutely, young lady.
Okay. Thank you.
So I know what your New Year's Eve job is going to be. It's going to be to clean up that unit.
God, I know.
All right, you take care. And we are going to move on to Ipanez. Ipanez, unmute yourself. Come on down.
L for Lynn.
Hey, how are you?
Thank you. How are you, Dennis?
I am good.
I'm wondering, for a non-RSO townhouse in Woodland Hills, for a just cause eviction, how do I know if I owe 1 month rent to the tenant who's on a monthly after 3 years, or if I owe the $9,000 crazy dollar amount?
There's never 1 month for a condo. Okay. You'd have to, they have a chart there. And I don't have it in front of me here, but there's a chart which tells you exactly what the relocation is, but it's not 1 month. 1 month relocation only applies to a single family residence. A condo, a townhouse is not a single family residence. It's
True.
anywhere from 9 to 12 up to $20,000,
That's just
depending on the
horrible.
non-fault reason. By the way, why do you want the tenant to vacate?
For a family member to move in.
Yeah, so you can certainly do that. You're going to have to comply with the relocation chart. Are the people over 62?
No,
Do they have children?
no.
Have they been there longer than 3 years?
Around 3 years, maybe 4 actually, but on a
Okay.
month to month for the last
You might
couple of
get a
years.
mom and pop exception because I presume you don't own more than 4 residential units in the city of Los Angeles. Is that correct?
You are correct.
So I think it's $9,500 off the top of my head is what you're going to have to pay, but it's certainly not 1 month's rent.
How do you get the mom and pop exclusion? And does that take you down to 1 month, or where does that bring
it
me?
brings you down to 9,500. Otherwise,
Oh,
otherwise you'd be up to like 9,800 or more. So the mom and pop just means that you don't own more than 4 units in the city of Los Angeles.
I see. And how does one, how often can I raise the rent to encourage my tenant to not want to live there?
On a townhouse, you're allowed to raise the rent as much as you like, whenever you like. So if you do go above 10%, it's a 90-day notice.
Okay. I
All
guess I
right.
have to start on that. And the frequency with doing a raise?
Well, look, if
I mean, because
you're
I raised
trying-
him in November.
Okay, you can do another one. The reality is that if the court looks at it like, hey, you're just raising rent, not because you want to raise rent, you're just trying to get them out, then you're trying to do indirectly what you can't do directly. And I've
Correct.
said in previous Zoom meetings, when I went to law school 50 years ago, oh my God. Can you
I don't
believe
believe
this?
it.
That's 50 years ago. I just looked at
Wow.
my diploma. I graduated in December 76. That was graduated 76. It's a lifetime. But as a law professor once told me that I never forgot, he said, Mr. Block, the law is not an ass. So if you're trying to do indirectly what you can't legally do directly, so you know what, I'm going to raise the rent from $2,000 to $10,000 a month. It's going to look like you're just trying to get them out. So you want to stay somewhat within the realm of believability so that somebody can't tag that line on
Right.
you, okay?
I would never want to do that. I'm very law abiding, but we did raise it in November only after reducing it during COVID.
Right. Well, again,
Brought
if
it
you
back.
can do another rent increase, again, it's got to be a 90-day rent increase. So
Okay. Thank you so much. Happy New Year.
same to you. Thank you so much as well. And let's move on to Christina Doran. Christina Doran, how are you? And unmute yourself, please. Oh, Christina, we love you. Are you there? We are going to move on then. Let's move on to Vincent. Vincent, I'm going to ask you to unmute yourself.
Hi,
Hey, how are you?
good. I have a tenant in the city of Long Beach that moved in her parents. So I need to raise the rent on them because two extra people moved in on a lease agreement. So how much can I raise the rent on that for that?
And I can tell you precisely that I don't know. You have to check the statute. You know, Long Beach has their own rent control statute. And though it follows the statewide statute, the statewide statute does not have any provisions for raising rent when extra people move in. Now, it might be in your rental agreement that says that if an additional person moves in, you're entitled to $100 for each additional person. If it moves in, and while there's been no court decisions on this, I think you'd be right in raising the rent for what it says in the rental agreement. Because my rental agreement from day one said, hey, the rent's $1,000, but if another person moves in, it's $1,100. So check your rental agreement and see what that says. If it has it in there, then I'm okay with that. I don't believe that Long Beach has a provision that says you can raise rent for extra people that move in, but you might want to check with the Long Beach Rent Control Board. I know, for example, that the city of Los Angeles says that you're entitled to a 10% rent increase, but I'm not sure what Long Beach says. You can't have all these statutes down. If I went down the list of all these municipalities that have them, it's literally insane.
Okay, thank you.
Thank you. Good question. Okay, let's move on to, I'm going to move on to Tanya's iPad because I like the people who I can actually see. And so I'm going to ask Tanya's iPad. Can you unmute yourself, please?
Hi, Dennis.
Hi
I have a
there.
question on the insurance. I got it from your website.
Oh, yes. I see it.
I'm right here. What do I put here on the second?
What city is your property located in?
Los Angeles.
Okay, for the
LA.
rest of the people who don't know what we're talking about, you can put that down, thanks.
Okay.
Love you. Most rental agreements state that a tenant must or may procure their own renter's insurance. Now, the reason why we put that into our agreements is because we don't want, for example, if a pipe breaks in the middle of the night, through no fault of the tenant and his water is cascading through his unit, we don't want to have a situation where the tenant's going to be looking towards us for compensation for all of the damage to his personal property or possibly his relocation expenses while the apartment's being done. So we want to have a paragraph in our rental agreements when they move in that says specifically, hey, you must or you may get renter's insurance. And if you don't, you cannot sue me. The only person that you can seek retribution from is from your own insurance company. So that's why we put that in there, to prevent landlords from getting served now with lawsuits. Now, if your rental agreement doesn't have that provision, then what you are holding up there is a 30-day notice change of terms of tenancy. Now, that's legal for both rent control and non-rent control. You can change the terms of the tenancy by serving that notice and say in 30 days, You may procure insurance, you must procure insurance. And if you don't, then don't come after me. Now, really, I don't think it makes a difference which box you check, may or must, because there was a court case that came down a few years ago that said you can't evict a tenant for failing to procure renter's insurance. I don't know why, but that's what it said. And it stated that it was not a substantial breach of the contract. So on that basis, I would definitely have that in every single rental agreement for every tenancy that you create. And if it's not in your rental agreement and somebody's already in, then assuming the tenant is on a month-to-month tenancy, you have the right to serve that notice on them. If your tenant's on a fixed-term lease, you have to wait for the lease to be over.
Okay, thank you.
All right, good question, Tanya. Okay, let's move on to Cara. Cara, I'm going to ask you to unmute yourself. Are you there, Cara? Okay, I think Cara's being entertained someplace else. Let's move on to a cell phone. Again, it's *6 to unmute yourself. The cell phone ends 0760, and I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
How are you?
You know, it's the day before New Year's Eve, and, you know, my plans are already set. So I think I'm doing okay.
Well, good. Dennis, so this is Diane Delaney, and I have a couple of questions. I have a non-RSO single-family residence in city of LA, and the tenants have been there a long time. The deposits are super, super low from many, many, many years ago. So can I, excuse me, request a higher security deposit? And because they're, I don't know, I have my own little affordable housing here. Can I let them pay on a monthly basis to bring up a decent security deposit?
First of all, what city is the property located in?
City of LA.
Okay, and so you cannot ask a tenant once they move in to pay additional security deposit. Those are new rules for the city of LA. The city basically, the city has implemented this policy based on a procedure that we were doing during COVID by raising security deposits. And when the tenant wouldn't pay, then we would evict them for failing to pay the security because we couldn't evict them for failing to pay the rent. So we came up with that idea, but the city of LA has put a squash to that method that we were using. I had about 300 very, very happy clients that we evicted their non-paying tenants who were buying new cars and going to Cancun and yet not paying the rent. So we kind of did an indirect way to evict them by raising the security deposit, but that's not proper now.
Darn. So I'll have no security deposit on the property.
It is what it is, young lady.
Okay, can I ask a second question since I
Yes, you
didn't get a great
can.
answer?
Then I'm going to try to go back to Cara because Kara's desperate to ask me a question. So Cara, hang tight. We'll see if I can get you in, but go ahead.
Okay. Okay, so I have a tenant that wants me to sign a paper allowing foster children in her home, and it's a very small home, and we've been reluctant, but we kind of want to get the property back from her. And she says that as soon as she has the foster care income, she wants to look for a bigger place anyhow. So can I negotiate with her that she give me a, excuse me, a 4-month notice to leave, and then I won't have to pay relo fees to her?
What city is this?
It's City of LA, single family residence.
Okay, and she says she wants to take in kids as foster kids?
She's signed up to get 4 of her grandchildren as foster children, and it's technically only a 1-bedroom, 1-bath that's got some sort of an extension.
Well, in the city of Los Angeles, if the first child's free, after that, you're entitled to a 10% rent increase. So you could go up the rent 30%. I wouldn't start an eviction based on unauthorized occupants when they're really their quote foster children, but you can go up.
Yeah. No, but I really just want, she says that she's going to leave. I mean, is that possible to negotiate that with her, that she give me that 90 or 120 day notice?
You can negotiate anything you want, but if she says no, there's really little that you can do. If she brings in the extra kids, then after the first child, you can charge 10% for each additional child.
Okay. Okay. Got it. Back
All
to
right.
Cara. Thank you. Happy New Year.
Same to you, darling. Okay, Cara, I don't know what to tell you. I'm asking you to unmute. There's got to be a button where it says unmute because I'm clicking on it. Otherwise, I think I'm going to have to let you call me at the office. But so I'm clicking unmute and everybody else is getting it. So maybe your microphone's dead. I don't know, but I love you. But I'm going to move on now to Richard Malley, who I don't mind telling you is, I believe, a very old client of mine. Richard, say hello.
Hey, Dennis, this is Richard.
Oh, now I get to see what you look like after years and years and years.
Right?
Yes.
A little bit of a raised heartbeat, just feeling like I'm back in court.
There you go. Now, what's in that case behind you?
My knife collection.
Your knife collection?
Yeah.
Oh, good. Well, let me make a note here. Never invite Richard to my office, okay?
Okay. Hey, I've got a couple of questions. In an Airbnb tenancy, which I'm thinking about doing, will the police come out and remove someone for squatting or overstaying? My concern is if the Airbnb customer subleases to someone else, then I'll have to evict the subleasee.
That's an unusual question that you're going to have. Usually the problems come is that the Airbnb person doesn't move. First of all, what city are we talking about?
Los Angeles.
Okay, you understand that there's a home sharing rule in Los Angeles? Are we talking about a single family home?
Correct.
Okay, so do you live in the home?
I don't.
You can't do Airbnb. So you have to live in the home to do Airbnb, and you
Okay.
have to be there, living there at least 2/3 of the years and rent it out maybe 1/3 of the year. And you have to have a home sharing license based on the Gestapo people that run our city. So technically speaking, if a person hasn't been there for 30 days, then technically you can just change the locks and get them out. But the police aren't going to help you with anything in that situation.
All right, understood. Great. My second question would be, in an LA RSO apartment, can I still accept the rent from a tenant after having served them with a 30-day notice to perform conditions, covenants, or quit, but before the lawsuit has been filed?
Now, that's an excellent question. My legal position is absolutely. So let's talk about, so the audience knows what we're talking about. I've got in the city of Los Angeles, if there's an extra person there, it's not a 3-day notice to perform or quit, it's a 30-day notice. In February, it will revert back to a 3-day notice to perform or quit. So, but in your situation, I'm serving you with a 30-day notice. And let's pretend I'm doing it today, which means that you've got 30 days to get rid of the stranger, which will bring us to approximately January 29th. Okay. Now, January 1st comes forward, and I serve that person, or the person comes to me with the rent. Well, I would think legally you should be able to take the rent, because I don't know whether you're going to comply with this notice or not. But the reality is right now you still have the right to comply. So it's not like I'm waiving the notice, okay? So I would think absolutely, legally speaking, that you should be able to take that money. But we lost a case on it. So there was some Yahoo judge who said, oh no, you took the money. This was for commercial where we had to serve a 30-day notice. You took the money, you waived it. And we kept jumping up and down. The problem with our kinds of cases is that we can, if judges make mistakes, attorneys make mistakes. I mean, that's why they have an appeals court, right? If nobody made a mistake, why would they need an appeals court? Why would you need the Supreme Court of the United States, which hopefully will rule quickly on that Trump issue? But notwithstanding that, but if you try to file an appeal, for an unlawful detainer action, it's going to take you like 9 to 12 months. So you might as well just start the case all over again at that point. And I think these judges know it, that while you have the right to appeal, and judges don't want to get appealed successfully, but while you have the right to get appealed, they know that, hey, who's going to really do that? So.
Got it. Got it. So I did it right by returning that check. Have a good-
I think based on what just happened to us, the answer is yeah.
Terrific. Wonderful.
Okay.
Well, thanks for taking your time.
Hey, nice meeting you face to face for a change.
All right. Have a good one. Bye.
All right, take care. Just because I want to, I am going to go back to Cara. Maybe you figured it out, Cara. I'm going to ask you to unmute yourself. And if you can do it, I know you're hitting unmute. I can ask my questions here. Okay, go ask your questions. She's going to type it to me and I'll read it, but do it quickly, young lady. I'm waiting. We don't want to slow the show down, you know, because this is show business. Maybe, okay. I have a tenant living in a 1-bedroom in the city of Los Angeles. Her father has moved in with her. Okay, that's nice. I'm all for family relations. So give me one more sentence and I'll give you a best answer I got. She has not admitted that her father is living with her. I think I got enough of the flavor. It doesn't matter whether she admits it or not, okay? If I tell you, you know, that I was born in Yugoslavia, you know, it doesn't matter what I say. It only matters what is the truth. And the truth is I was born in New York. I wasn't born in Yugoslavia. So if you see this person there for over 30 days in the city of Los Angeles, then that person becomes not a guest, okay, but becomes an occupant in the unit. And if that person is an occupant in the unit, I can serve that person with a 30-day notice to perform or quit, giving him 30 days to get rid of dad. And if dad is still there at the end of the 30th day, I now have the right to evict everyone from the unit. In addition, if you don't want to do that, the city of Los Angeles requires that you serve a 10%, you can get a 10% rent increase. If you're going to do that plus the 4%, then the 4% would take effect as of February 1st. And then you do a 90-day notice for the additional 10%. Now, don't take the 10% with the rent plus 4%. Take the 10% just on the base rent as it is right now. Hopefully that answered your question. We're going to move on. Let's see. I have an iPhone here. It just says iPhone without a number. I'm going to ask you to unmute yourself. Mr. or Mrs. iPhone, can you unmute yourself? If not, I am going to move on. Let's move on to Karen Kahara. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hey there.
Thank
How
you.
are you, darling?
I'm good, thanks. So a 3-day notice was posted on the door on Wednesday,
Uh-oh. Go
the
ahead.
27th. What is the count?
The tenant's
it
going to have
like
until Tuesday
Tuesday?
midnight to pay. You did it on Wednesday, so Wednesday is day 0. Thursday is day number 1. Friday is day number 2. But Saturday, Sunday, and judicial holidays like January
Doesn't count.
1st doesn't count. So the tenant's
Okay.
going to have until Tuesday midnight to pay you. And then do you know what you do on Wednesday, Karen?
No. What do I do? What do I do?
You don't know? I'm shocked. What you do is you call me. Why do you
Okay.
think I'm here?
Okay.
So I can start the eviction for you, sweetheart.
But we already did. I spoke to you on Tuesday.
Okay, well, okay, so then we're talking about a case that was served the week before then. Okay, you've already given me the case. Okay, so I
Yeah.
see what you're saying. I don't like to talk about existing cases, but if in fact you did serve it on that date, then a lawsuit could be filed as of Wednesday, because they'll have till Tuesday to pay. Okay?
One more small question.
Yes, darling.
So she received the notice and we moved it from the door, but she left, and she left all the windows open in the unit. I have hardwood floors throughout, and it's raining. I mean,
I
do
think you could serve a notice to go in there to close the windows, unless you can
A
do it from
20
the outside. Doesn't necessarily.
No, it's an upstairs unit, so a
Yeah.
24-hour notice
Yeah, I would do a
should
24-hour notice that I'm going in there to protect my property because you're a moron and you left the windows open during a rain.
Okay.
Okay?
I don't need to call her. I just need to
I would
post
just, well, you could call her and tell her I need to go in, can I? Because you left your windows open. And then if she says no, then I would just serve a 24-hour notice.
Okay, thank you. Happy New
Okay.
Year.
However, if you do think that your property is
Uh-huh.
going to be really damaged, then you don't need a 24-hour notice. So if you can see, hey, the rain is coming in to this property and I don't want my floors damaged because quite frankly, that's going to be the tenant's responsibility. Then in that situation, I would just go in without a notice, knock on the door and go in. If truly you think your property is going to be damaged if you wait that one extra day.
Well, she's already damaged. I already fixed the hardwood floor from the Hurricane Hillary or something.
All right, well, if the
floor,
windows are still open and you think that they're gonna get damaged by the rain, then I would definitely go on in on an emergency basis. I'm gonna say goodbye to you,
Okay,
young
thank you.
lady. Happy New Year. We're gonna pick on Lisa right now. Lisa, could you unmute yourself?
Hi, Dennis.
Hello, Lisa.
Yeah. Happy New Year. I have a few questions, if I can, please. The first question, by California law, if we can charge pet fee beside of the deposit.
Okay, there is no such thing in the state of California as a pet fee. There's no such thing in the state of California as a last month's rent. It's all considered a security deposit. Currently, for an unfurnished unit, you can go up to 2 months' rent, but it's only called a security deposit. And by the way, you don't want to call it a pet deposit. So if you got 1 month's security deposit, and let's say I got a $500 pet deposit, what happens is the guy gets rid of his dogs and he walks over to you and says, hey, I want my $500 because there's no dog here. Now what are you going to do? So it doesn't make any sense to take a quote pet deposit, but in any event, it's legally you're not allowed to. It's just called a security deposit. It's to your advantage not to call it a pet deposit.
If that happened without knowing the law, the tenant can sue for that.
I know the tenant can't sue for that. The tenant would, the law says that any deposit that you take is considered a security deposit. Okay?
The deposit is 2 times of the rent. On top of that, the pet fee.
Then you need to give the pet fee back because you've exceeded the state limit of 2 months rent.
I see. My second question for if tenant trying to sue and they do not do proper they don't serve properly, if there is any chance for they can go and make a judgment on a landlord's name?
Okay, so what you're talking about is the tenant filed a civil suit against you and they didn't really serve it right. Maybe they handed it to your manager or they handed it to another tenant or something and you weren't properly sued. And therefore, you're wondering whether in fact they can get a judgment against you.
Yes.
You know, here's how it works. It's beyond stupid. If you got a copy of the lawsuit, don't play the game. Oh, I haven't been served.
No, we don't.
Give it.
We don't.
Oh yeah, good. Give it to an attorney because what they'll do is they'll pretend they served you. They'll file a default against you. Then you're going to have to hire an attorney just to spend extra money to get the default set aside, which the court will, but it's just going to cost you more money. If there's a lawsuit out there and somehow they're trying to give it to you, regardless of whether it was a legal method or not, if you know about it, I would deal with it at that point. I'm going to move on. Lisa, I'm going to move on because I want to get to Christina. Sorry, young lady. I want to get all the calls in and we're right at that precipice. So I'm going to ask you to unmute yourself, Christina.
Can you hear me?
I hear you wonderfully.
Awesome. Okay, I have a tenant that has a past due rent that was from April 22 through January 2023 in the amount of $9,625. And I know that I am allowed to collect that February 1, 2024. Is that correct?
You got those dates perfect.
So here's the thing is there are 2 tenants in this apartment, and the other roommate has paid all throughout the whole pandemic. This other roommate they've just completely worked the system, and I've gotten reimbursed from the state for the periods that were due in the past, but for that single roommate, if that roommate doesn't pay on the 1st of February, do I go after both of the roommates on the lease?
You have one rental agreement, correct?
Yes,
With 2 names in it.
correct.
Okay, let's pretend, because I love hypotheticals. Let's pretend you rented to a husband and a wife, 2 people. And the husband always pays half the rent, and the wife claims COVID. Would you consider just going after the wife in that situation?
No, I would go after both of them.
Okay. So the issue is, what you have to consider is, if you rent to more than one tenant, who's renting your unit is a partnership. A partnership. And a partnership rented the unit, and the partnership is supposed to pay the rent. If the partnership didn't pay the full amount of rent, then the partnership is going to be the subject of the eviction. So when I say partnership, I mean everybody.
So I've been sending each month a notice of the balance due. So do I need to send them a notification that it is due and payable on February 1? Or
Absolutely. Tell them that, hey, by the way, your reign of not paying me the rent is coming to an end. It is so outrageous. I was reading the LA Times. I don't know why I read that rag paper, but I was reading the LA Times yesterday and say evictions are up 200%. And this is terrible. All these people, and this one woman's in court, and she's going to lose her rent control apartment of $740. It's going to cost her 3 times to get. Are you out of your mind, LA Times? First of all, you stopped landlords for 3.5 years from bringing forth eviction cases, right? So don't you think after 3.5 years that more people are going to be filing these things? If they told pizza parlors you couldn't sell pizza for 3.5 years, you think there'd be a bunch of people lined up to buy pizzas? And the other thing is, this poor woman, $750, she's going to lose her rent-controlled apartment. I have an idea. Why didn't she pay the rent if it's only $750? You're telling me that COVID went on for 3.5 years? Give me a break. Maybe people were affected the first year with COVID, but not after that. People gamed the system. 99% of the people gamed the system and pretended that they couldn't pay the rent. So in your situation, you tell them that if I don't get all my rent on February 1st, then on February 2nd, I'm serving you guys with a notice. Now, it's not a 3-day notice. It's a special 15-day notice that has to be set up, showing each month that for February X amount became due, for March X amount became due. It's not like the standard 3-day notice. So
right,
I would recommend that you call our office. We have reached our time period. Ladies and gentlemen, thank you so much for participating in this. I will be doing this every single Saturday at 3 o'clock. So just come on in and we'll get all your questions answered. I think we got to everybody today. I think we had a few that tried to do more than one question. So I certainly appreciate your efforts. I want everybody to have a very, very happy new year and a very prosperous new year, as we kind of meander through the landmines that our politicians have that puts the onerous on income property owners. But once again, Happy New Year's, be safe, and I guess I'll see you next year Saturday. Okay, everybody, take care.